In the vibrant commercial hub of Lagos, a seemingly straightforward tenancy dispute between Dr. Charles Mekwunye, the landlord, and his tenant, Christian Imoukhuede, spiraled into a decade-long legal saga, meticulously testing the very foundations of arbitration in Nigeria. Their lease agreement, like many others, contained an arbitration clause, a standard provision intended to provide swift, private dispute resolution. It stipulated that any disagreement would be referred to a sole arbitrator appointed by the President Chartered Institute of Arbitration, London, Nigeria chapter. Little did they know, this precise wording held a pathological clause, a defect so subtle yet potentially devastating. The named body, Chartered Institute of Arbitration, London, Nigeria chapter, simply didn't exist. The correct institution was the Chartered Institute of Arbitrators, UK, Nigeria branch. When a dispute inevitably arose, Mekwunye initiated arbitration, writing to the chairman of the actual UK Nigeria branch, who duly appointed an arbitrator. Imoukhuede initially challenged this appointment, only to withdraw his objection and participate fully in the proceedings. The arbitration concluded, and an award was rendered in Mekwunye's favor in May 2007. But Imoukhuede was not content. He approached the Lagos High Court to set aside the award, arguing that the entire arbitration was fundamentally flawed due to the non-existent appointing authority mentioned in the clause. The High Court, however, saw through the technicality, affirming the clear intent of the parties to arbitrate and dismissed Imoukhuede's application. Undeterred, Imoukhuede appealed to the Court of Appeal. This time, the literal interpretation prevailed. The Court of Appeal, focusing strictly on the flawed wording, sided with Imoukhuede and set aside the arbitral award, casting a dark cloud over the sanctity of arbitration agreements in Nigeria. This decision raised alarm bells across the legal community, threatening to prioritize technicalities over the parties' true intentions. The fate of arbitration in Nigeria hung in the balance, as Mekwunye appealed to the Supreme Court. In a landmark unanimous decision delivered on June 7, 2019, the Apex Court unequivocally reversed the Court of Appeal's ruling. The Supreme Court declared that parties are bound by the terms of their contract, including errors they may have condoned or waived. Given Imoukhuede's active participation in the arbitration and his earlier withdrawal of the challenge, the court found he had waived his right to object. This judgment powerfully reinforced the Nigerian judiciary's pro-arbitration stance, upholding the principle that the substance of an agreement to arbitrate outweighs mere technical defects, especially when the party's intention is clear. The Mekwunye versus Imoukhuede case is a powerful reminder that even seemingly minor drafting errors can lead to protracted and costly legal battles. For modern businesses, such pathological clauses are unacceptable risks. This is precisely where platforms like MavericksAI become invaluable. By leveraging advanced legal automation, MavericksAI can meticulously review and flag ambiguous or defective arbitration clauses, ensuring clarity and enforcement from the outset. It transforms legal risk into operational certainty, saving time, resources, and safeguarding the true intent of commercial agreements.